Good morning. Welcome to the Judicial Committee of the Privy Council. This morning we're hearing an appeal from the Court of Appeal of Jamaica in the matter of Hinds and others against the Director of Public Prosecutions. The appeal concerns the principle of open justice and the extent to which it applies in the context of requests for mutual legal assistance. The particular question is whether evidence to be taken from the appellants pursuant to a request for mutual legal assistance by the Netherlands should be given in open court rather than by a judge in private. I'm Lord Lloyd Jones. I'm sitting today with Lord Hamblin.
Good morning.
Lord Leggett.
Good morning.
Lord Stevens.
Good morning.
And Lady Dorian.
Good morning.
The appellants are represented by Alexis Robinson. The respondent, the Director of Public Prosecutions, is represented by Peter Knox, Queen's Counsel. Ms. Robinson.
Good morning, my lords, my lady. May I first indicate that with me today is Amanda Montague, and we are instructed by Myers Fletcher. Since the principle of open justice and its application to court proceedings was at the heart of the Honourable Mr. Justice Campbell's decision at first instance, that the evidence should not just be given in open court, but in public with media access, I would like to start there. I propose to then look at investigative procedures and confidentiality, and will close with comments on matters which were considered by the learned judge bill, which the appellants submit are irrelevant. I will start then with section 16.3 of the Jamaica Constitution, which reads, all proceedings of every proceedings and proceedings relating to the determination of the existence or the extent of a person's civil rights or obligations before any court or other authority, including the announcement of the decision of the court or authority, shall be held in public. The subjecting all proceedings of every court to public scrutiny fosters public confidence in the administration of justice. That is the rationale for the principle. As a codification of the common law, the word proceedings in section 16, subsection 3 must be interpreted with this fundamental objective in mind. The appellants submit that on a literal or any interpretation of section 16, subsection 3, it is the court and its proceedings, or other proceedings before any court or other authority where civil rights and obligations are determined, that are subject to the principle, and not proceedings generally. Further, the authorities, including those relied on by the judge below, make it clear that the principle does not apply even to court proceedings which are not in the ordinary course of litigation, such as pretrial proceedings. And that's to be found in the case of Hodgson against Imperial Tobacco, which is at MS 1138. Section 20, subsection 1 of MAPA makes provision for the central authority, that is the Director of Public Prosecutions, the DPP, to, in her discretion, authorize writing of evidence. Under subsection 2, a judge of the Supreme Court may take the evidence on oath of each witness and shall then cause the evidence to be put in writing, certify that it was so taken, and cause the writing so certified to be sent to the DPP, who then transmits it to the foreign state. In section 20,
Ms. Robinson, what procedure are you referring to now?
The section 20 of the Mutual Assistance Criminal Matters Act.
Right.
It's at MS 738. And in section 23 of that act, there is a reference to the judge of the Supreme Court conducting a proceeding under subsection 2. So there is reference to what is provided for under subsection 2 as a proceeding in subsection 3. And the judge is given the power to order anyone to attend the proceeding and to give evidence. It is the appellant's submission that the fact that subsection 3 of MACMOS, section 3 of section 20 of the Mutual Assistance Criminal Matters Act, which I will be referring to as MACMOS, the fact that that section refers to proceeding does not turn what is provided for in section 20, subsections 1 and 2 into more than the evidence-taking exercise that those provisions actually describe. It's a question of substance over form. Indeed, the DPP agrees, because in her affidavit in support of the fixed date claim form, having stated at paragraph 19, which is at MS 15, that she is exercising her discretion to seek the orders. She says at paragraph 28, 2 pages over, that she is satisfied that these proceedings are not a trial, but only a process for the gathering of evidence. That is what is before this court, the evidence-taking exercise under section 20, subsection 2. And it is submitted that this exercise not involve any question of maintaining law and order, establishing peace and security in Jamaica, which are aspects of the administration of justice. Are you having difficulty hearing me, my lords?
At the moment, we can just about hear you. I don't know if my colleagues are having the same difficulty. Yes. If you could speak as close to the laptop as possible, I think that would assist.
Okay. To the extent that the evidence-taking exercise may involve the protection of the rights of individuals and the enforcement of laws, such as if whenever a person is questioned, for example, even by their employer in a disciplinary hearing, where rights to a fair hearing, legal, professional privilege, and counsel are all engaged. These are exercised by the authority, to use the language of section 16.3, which is authorized by the DPP to take, certify, and send the evidence to the DPP for onward transmission to the requesting state. As the DPP said, this is not an adjudicatory function, and she said that in the same affidavit in support of the fixed date claim form that I referred to at MS 17. It happens that the authority who the DPP authorizes is, in fact, a judge of the Supreme Court. It is the submission of the appellants that the judge of the Supreme Court is not to be mistaken for the Supreme Court itself. Sections 39 and 40 of the Judicial Supreme Court Act, which are in the bundle at MS 987, make it clear that this is not the case. In fact, neither section, which together outline the circumstances in which a single judge of the Supreme Court may exercise the jurisdiction of the court, applies to section 20 of MACMA. Indeed, it would be contrary to the doctrine of the separation of powers for the DPP to be authorized to authorize the power to authorize the Supreme Court to act as a court, which is what the respondent's interpretation requires. Section 2 of the Constitution also provides that if any other law is inconsistent with the Constitution shall prevail, and the other law, to the extent of the inconsistency, is void. This is to be found in the case of William Clark against the Bank of Nova Scotia, which is at MS 1396. There have been no amendments to the Constitution to give effect to the interpretation relied on either and court. Furthermore, the judge or authority in the section 20 evidence-taking exercise is not determining a person's civil rights or obligations. In fact, there is no trial which is capable of determining any rights or obligations. And this was tacitly accepted by the Constitutional Court at paragraph 214 of that judgment, which is to be found at MS 1380. It is therefore self-evident that Section 20 proceedings are not in the ordinary course of litigation. Litigation has not even begun. There is no administration of justice to be protected, and therefore, in keeping with the known exceptions to the open justice principle, even if Section 20 of MACMA were considered to be before a court, they would be exempt from the principle of open justice. More than that, because the evidence-taking exercise of Section 20 of MACMA is not under the jurisdiction of the Supreme Court and is not determinative of any civil rights or obligations, Section 16, subsection 3 of the Constitution does not apply. The Honourable Mr. Justice Campbell had no discretion to order that the proceedings were to be held in public. If I may take you a little deeper into the interpretation to be given to the word proceeding in Section 20 of MACMA, I wish to point out that, save for Section 20, all of the other references to proceedings in Part 2 of that Act concern requests by a foreign state, as here, relate to criminal proceedings, which is a defined term in the legislation, or a trial or proceeding to determine whether any person should be tried for an offence. Curiously, where local courts are involved in MACMA, those applications or claims are not referred to as proceedings in the legislation. And this is made clear when one looks at the instrument of designation of central authority, which is at MS 988, which I would like to take you to now. That was MS 988. There you will see the Jamaica Gazette Extraordinary of Friday, May 2, 1997. Under the title Instrument of Designation of Central Authority, it reads, pursuant to Section 2 of the Mutual Assistance Criminal Matters Act 1995, I, Keith Desmond St. Aubin Knight, Minister responsible for justice, do hereby designate the Director of Public Prosecutions as the central authority for the purpose of performing the functions and duties specified in the schedule to this order. Turning the page, you will find the schedule to the order, which is in 2 columns, the first setting out the section of the Act, and the column on the right showing the functions that the DPP is designated to perform. The first paragraph in relation to requests by Jamaica of a foreign state, there is only under Section 8 reference to a local court proceeding, in that the DPP is authorized to request the issue of a warrant by a resident magistrate in relation to a foreign inmate. Down the page, halfway down, paragraph 2 starts in relation to requests by a foreign state to Jamaica. And there, the only references to local court proceedings are to be found at the bottom, Section 23, subsection 1, where the DPP is designated to authorize a police officer to apply to a resident magistrate for a search warrant. Section 23, subsection 7. I'm sorry, not Section 27, subsections 1, 2, and 5, where the DPP has a function of making an application to the Supreme Court for the registration of various foreign orders. And turning the page over, Section 27.8 and Section 28.1, which allow the DPP to make on behalf of a foreign state an application to the Supreme Court for a forfeiture order or pecuniary penalty order, and authorize her to have a police officer apply to a resident magistrate for a search warrant, respectively. Section 29 also authorizes her to make, on behalf of a foreign state, an application to the Supreme Court for the issue of a restraint order. So we can see that whereas sections 8, 23, 27, 28, and 29 clearly speak to functions that the DPP is designated to perform that involve a local court, there is no court involved in the DPP's stated function in relation to section 20, which is there at MS 989. Her stated function in relation to section 20, which is the section under consideration in this appeal, is authorizing A, the taking of evidence or the production of documents for other articles requested by a foreign state, and B, the transmission of such evidence, documents, or other articles to the foreign state. One could then reasonably ask whether the DPP in fact had jurisdiction to commence these proceedings. Although she said in her affidavit that she was exercising her discretion, she has no such discretion listed in her functions as central authority. Also, in section 94 of the Constitution, which creates her office, her only relevant constitutional power is to institute and undertake criminal proceedings against any person or any court. So it is clear that she cannot have been acting under any other authority when she instituted these proceedings by fixed date claim form. Going back to the instances in MACMA where the DPP's functions include referring matters to local courts, the relevant sections for our purposes are sections 23, 27, 28, and 29. And it is notable that in all of those sections, a criminal proceeding has to have started. In fact, in one of them, a conviction has to have been obtained. So if I can carry you through, section 23 is in relation to applying to the parish judge for a search warrant and is only allowed where a proceeding or investigation relating to a criminal matter has commenced in the foreign state. It's important to note this distinction because generally under part 2, which is where section 20 falls, assistance can be provided even if there is a reasonable cause to believe an offense has been or is likely to be committed. And that can be found at section 50, which is at MS 734. Section 27 concerns requests from a foreign state for the enforcement of foreign orders and grants the central authority discretion to apply for the registration of such orders in the Supreme Court if satisfied that a person has been convicted of a relevant offense and that the conviction is not subject to further appeal in the foreign state. Section 28 also requires that a criminal proceeding or investigation has commenced in a foreign state in respect of a prescribed offense. And section 29 requires that a criminal proceeding has commenced and allows the central authority to apply to the Supreme Court for a restraint order. Authorized requests of foreign states to court in Jamaica are therefore circumscribed to when a proceeding or investigation has commenced or a conviction is considered final. It therefore stands to reason that section 20 is not an instance where the DPP is authorized to go to a local court, because section 20 operates even where there is only reasonable cause to believe an offense has been or is likely to be committed. For all of these reasons, the appellants submit that the word proceeding in section 20 of MACMA should not be interpreted to mean the same thing as proceedings in section 16 subsection 3 of the Constitution. Even if section 20 proceedings are deemed proceedings for the purposes of section 16.3 of the Constitution, the appellants submit that they are not subject to that section of the Constitution, as they are nevertheless not proceedings before a Jamaican court. In any event, they are not in the ordinary course of litigation and would therefore fall into the category of known exceptions to the open justice principle. Turning now to investigative procedures. The first schedule of MACMA provides that the requesting state can indicate the manner in which the evidence is given. In case, even if the Dutch had asked for the evidence to be taken in public, which of course they did not, Section 19 of MACMA clearly provides that requests to Jamaica shall be executed in accordance with the relevant laws in force in Jamaica.
Well,
And the
Ms.
procedure.
Robinson, forgive me, you say that they did not, but they did ask that, I think in the 9th supplementary letter of request, they did ask that it be taken by a judge in court.
Thank you for that question. If I could take you to the 8th supplemental letter of request, which is at MS 172. I would like to show you that in the 8th supplementary letter of request, which is dated April 14, 2019.
2009, yes.
I'm sorry, 2009, yes. At the bottom of page 172, they indicate that during the execution of the letter of request in January 2008, it turned out that a number of witnesses were not willing to cooperate with an interview to which they had been invited as witnesses. And turning over the page, it is because of that occurrence that then the middle of the page of 173, underneath the list of witnesses, it reads, in anticipation of the possibility that the witnesses would not appear at the appointments we have made, we include the following request in the 5th supplementary letter of request. And there is the request for judicial summons of the witnesses. Since a large number of the witnesses we had invited did not appear and advised us that they do not wish to cooperate with an interview just like that, I hereby ask you, on the basis of the Jamaica Mutual Assistance Criminal Matters Act, Section 20, to request the judge of the Supreme Court or the resident magistrate to order the witnesses to attend the proceeding and to give evidence to produce any document or other articles at that proceedings. And then at the bottom of page 2, in the letter of request indicates that during the interview of the witnesses, we were allowed to ask a number of questions. However, the witnesses turned out not to be prepared to answer the questions asked. They all answered with a similar statement. And there's a quotation, if my assistance is requested in an investigation of bribery, I cannot be of any assistance because I do not know anything about that. And turning now to the last page of that letter, it says that during the execution of the letter of request in March 2008, it was not possible to have the judge of the Supreme Court or the resident magistrate conduct interviews with the witnesses under Article 20 of the Jamaica Mutual Assistance Criminal Matters Act in the short term. And there again, the request is made in the middle of the next section, request for judicial summons of the witnesses on the basis of MACMA Section 20. We request the judge of the Supreme Court or the resident magistrate to order the above mentioned witnesses to attend the proceeding and to give evidence or to produce any document or other articles at that proceeding. Now, I took you there to show you that there is what is asked for in the 8th supplementary letter is the same as what is asked for in the 9th supplementary letter. And if I could take you to page 175, which is the 9th supplementary letter, you'll understand why the 9th supplementary letter was written. That letter, which is dated May 25, 2009, at the bottom of the first page, indicates that on April 30 of 2009, so just after the 8th supplementary letter, Mrs. Caroline P. Hay, Senior Deputy Director of Public Prosecutions, asked for additional information in relation to Section 3 to the schedule of the Mutual Assistance Criminal Matters Act. Turning the page at the top, it continues that apply to the letter of Mrs. Caroline Hay And in addition to the 8th supplementary letter of request, I can provide you with the following information. So the information that comes after this is not to be seen as a change of instructions. It is further and additional to because of a request from the DPP. It is there.
If we go to subparagraph D, that's not the provision of further information. This is a request that the evidence be taken by hearing conducted by a judge in court.
Yes, so providing the further information, one of the things was that they be witnesses to give evidence. Oh, I'm sorry, can you hear me now?
Yes.
Okay.
Could you repeat, please?
Yes, so I was saying that the information provided in response to Mrs. Hayes' letter is there listed at sub letters A to E, so it includes D referred to, and in D there is that issue of requesting the evidence to be taken by hearing conducting by a judge in court, but we would say that this is really just loose language referring to what was already asked for in the 8th supplementary letter, which was which in fact quoted section 20 of MACMA. And we are fortified in this position by the fact that subsection E says that there are no special requirements concerning the manner in which the evidence is to be taken, other than that the evidence is given under oath or affirmation. Certainly, evidence can be given under oath or affirmation without being in public. It also does not necessarily follow that because there is a mention of court, that it must be that the court is in public. And certainly not with media access.
My question related to your submission that your words, of course, it had not requested that it be held in public. And I was drawing to your attention the statement that we wish the evidence to be taken by hearing conducted by a judge in court. You say that's loose language, which is intended to reflect the 8th letter of request. Is that 8th supplementary letter? Is that right?
Yes, and that in any event, court does not necessarily entail a public hearing.
Thank you.
Yes, because court could be a reference to in chambers, for instance. I was at section 19 of MACMA, which provides that requests to Jamaica shall be executed in accordance with the relevant laws in force in Jamaica and the procedures applicable under those laws. The appellants submit that section 19 requires that witnesses are to be treated as though they are giving evidence at the investigative stage in this jurisdiction. The same procedures, the same safeguards, and the same considerations ought to be made. Of course, requests to the foreign state are to be accommodated, but only to the extent that they are consistent with the laws and procedures in force in Jamaica. It is submitted that section 20 proceedings are most analogous to a question and answer in Jamaica. Regular practice and procedure for question and answers in Jamaica is that the taking of evidence at this investigative stage is done in private at a police station in a private room. In fact, the witness statements remain private and are disclosed to the accused when the judge orders disclosure at the arraignment after the return.
A question, I've been unmuted to ask it. In relation to the question and answer procedure, is the witness put on oath?
I'm sorry, is the witness
put on oath or affirmation?
No, they're not.
Thank you.
Thank you. And is the Q&A procedure conducted by a judge?
No,
Well, it doesn't bear any relation to this procedure then, does it?
well, we would say that it is similar because in the Dutch, in this case, what is under consideration is a question and answer situation where the Dutch authorities have indicated what the questions are, and the local authorities are being asked to get the answers from the witnesses. The DPP was originally going to do that in an office setting for under the earlier supplementary letters.
Is the interpretation of
Put into
section,
effect. I'm sorry.
is the interpretation of section 19 not meant to indicate that it should be executed according to how evidence from a judge would be taken in Jamaica? Evidence in front of a judge.
Well, I would say that that would not be the case, because what we're dealing with here is a situation where we're still at the investigative stage. Our local jurisdiction, evidence is taken before a judge in the process of an adjudicatory function that judge is carrying out. As sections 39 and 40 make it clear that what is happening under MACMA is not happening within the jurisdiction of the Supreme Court. It's happening outside of that jurisdiction. It's of convenience that it is a judge of the Supreme Court that has been designated to do this function, but it is not to become analogous to regular court hearings before a judge in that jurisdiction. All that has happened is that the investigation is now being cloaked in some formality under Section 20, and that section authorizes a judge of the Supreme Court to take the evidence in a capacity which is not the same capacity under the Judicatory Supreme Court Act. So we would be looking for an analogous situation in relation to how evidence is normally taken. The matter is in court and under the regular jurisdiction of the Supreme Court. This is really much more analogous to a situation where gathering exercise prior to trial, prior to proceedings having been started, prior to charge even, these people are witnesses, and the question and answer in Jamaica is really the most analogous situation that there is in relation to finding what Section 19 says is in accordance with the relevant laws of force in Jamaica under those laws. There is also the sections 34 and 35 of the Justices of the Peace Jurisdiction Act, which deals with committal proceedings for people charged with indictable offences and the taking of the evidence of witnesses in such proceedings. In that act, under Section 35, the room or the building in which the justice or justices shall take such examinations and statements as aforesaid shall not be deemed an open court for that purpose. The Extradition Act is also worthy of noting here, especially because its object and purpose is very close to MACMA in the sense of having local proceedings which support foreign proceedings. Its provisions and the procedures adopted in it make it clear that as a matter of practice, statements from witnesses taken under the Extradition Act are never taken in public. That is definitely more analogous to the situation under Section 20 of MACMO. And certainly, there is good reason for these procedural safeguards at this investigative stage of the proceedings, and which ought to extend to the circumstances under consideration. In Jamaica, witness statements remain private. If the taking process was public, then all potential tribunal of fact or jury members would automatically be tainted, as they would already have seen and heard the evidence. This directly affects the appellant's right to be heard by a fair and impartial tribunal, including a jury, if they are ever charged in Jamaica. Submit that in the circumstances of this case, the judge had no discretion to order the evidence to be taken in public and violated Section 19 of MACMO by ordering a public taking of the evidence because Jamaican stage of proceedings under Jamaican laws, whether for local proceedings or overseas proceedings, have their evidence taken in private. The request from the Dutch authorities was made under the 2000 United Nations Convention Against Transnational Organized Crime Treaty. And that treaty is clear on the need for confidentiality as a right of the requesting state, in order to ensure that its criminal investigation and or proceedings are not prejudiced.
Now, Ms. Robinson, I think your point on confidentiality is a new
In the UK,
argument, isn't it? Which wasn't taken below?
that is correct, and I raised that in my written case.
Well, it's not the normal practice of this court to hear submissions which were not raised in the courts below.
Yes, but I see that my my learned friend, Mr. Knox, has substantively responded to this submission.
Well, he has, but he maintains his objection in relation to this particular ground, which you've not advanced before.
It does, if I may, the matter of confidentiality of the letter from the matters before you, it arises on the face of things, and I would ask that I be allowed to speak to the I will say that my friend has put in, and so I will steer away from that. But if I may be allowed to discuss aspects that he has responded to, I would.
Well, we will hear you without prejudice to the objection which Mr. Knox has raised, and so we'll hear you in relation to this point. Please continue.
I'm grateful. I was saying that letters of request are formal and highly confidential documents in the UK, and in relation to a case relied on by both sides, the case of ZXC against Bloomberg. The intended result, well, Millards, the submission really on confidentiality is contained in this. In light of the confidentiality that clearly attaches to the letters of request, the order for a public hearing should not be allowed to stand. The public taking a positive on the subject to cross-examine proceeding.
I'm sorry, Ms. Robinson, the line is breaking up. We're going to have to ask you to repeat
Evidence
that.
and possibly make it of no use.
Ms. Robinson, the line's breaking up, I'm afraid. Going to have to ask you to repeat that submission.
Can you hear me now?
Yes?
The submission was that in light of the confidentiality that clearly attaches to letters of request, as shown in the case of ZXC and Bloomberg, and in the guidelines published by the Central Authority in Jamaica, the order for a public hearing should not stand.
Question from Lord Leggett.
What do you say about section 24 of the Mutual Assistance Act on page 744?
I would say that section 24 is consistent with sections 27, 28, 29, and 23 that I took you to in the order, designating the DPP as the central authority.
Well, did the central authority require the evidence to be kept confidential in this case?
No, the central authority did not specifically require confidentiality, but in the scope of the legislation, there is no confidentiality where criminal proceedings have already commenced. And consistent with the confidentiality of letters of request generally, section 24, all section 24 does is give the DPP discretion to impose conditions upon which confidentiality may be waived.
No, it doesn't. It gives the power to require to be kept confidential, what by implication otherwise need not be kept confidential. So if there was no requirement in this case, that shows, doesn't it, that there was no confidentiality in the evidence?
Well, this would be the case where there are criminal proceedings, but consistent with the DPP's own published guidance, the letters of request ought to be treated confidentially.
But they weren't. So they were entitled to be given in public, the evidence.
Well, we would say that we would say that the judge of the Supreme Court in this circumstance ought to have considered the confidentiality of the letters of request.
Was he asked to by counsel? Did counsel ask him to keep the information confidential, relying on any provision about confidentiality? Was that submission made to the judge?
No, there was no specific reference to the letters of request being confidential, but there was a request for the information to be taken in private.
Thank you.
Obliged. The process embarked upon by the DPP, arguably without express authority, was, we submit, a breach of the confidentiality inherent in the letters of request. And in addition to the procedural risks that I have indicated, exposed the witnesses to concerns about potential liability, reputational risks, and political damage. And this type of damage was under consideration in the case of ZXC against Bloomberg at paragraph 82, which is at MS 1454. And there at paragraph 82, the Lord Justice Simon said that he would like to take the opportunity to make clear that those who have simply come under suspicion by an organ of the state have, in general, a reasonable and objectively founded expectation of privacy in relation to that fact and an expressed basis for that suspicion. The suspicion may ultimately be shown to be well-founded or ill-founded, but until that point, the law should recognize the human characteristic to assume the worst, that there is no smoke without fire, and the human characteristic to overlook the fundamental legal principle that those who are accused of an offense are deemed to be innocent until they are proven guilty. In the present case, Lord Justice Simon continued, the claimant has not even been arrested. And in this case, we would point out that the appellants have not been arrested and are in fact not even under investigation.
Ms. Robinson, Lord Hamlin has a question for you.
Yes, Ms. Robinson, was there any evidence before the judge about potential damage or prejudice to the appellants. You refer to political damage, reputational risks, potential liability, and so on. Was there any evidence about this?
Yes, so it is true to say that in the courts below, there was not much evidence of this provided to the court. However, I would say that the court could have taken judicial notice of it, the appellants all having been members of government. And indeed, the judge below did comment on the public nature of the public characteristics that they imbued. So I would say that it wasn't necessary in the circumstances. In fact, the reading of the judgments below is replete with that kind of information about the public nature of these appellants and of the particular matter under consideration. The roles that they played, there was constant references to the public nature of what was happening. And so this idea of reputational risk and political damage would certainly have been within their consideration. If I may continue at paragraph 84 of ZXC.
Sorry, Ms. Robinson, before you move on, could I have your comments as to the passage at the top of page 1455, where giving the judgment of the Court of Appeal, it's accepted that there may be some cases where the reasonable expectation of privacy may be significantly reduced, perhaps even to extinction, due to the public nature of the activity under consideration.
Yes, thank you for the question.
Isn't that just this case?
Well, actually, in this case of ZXC, what was under consideration were offenses which included corruption and bribery, just as the offenses in this case concern issues of bribery. And so it is very interesting and noteworthy that Lord Justice Simon, when he speaks of the fact that there may well be cases where the expectation of privacy is extinguished, his examples are rioting and electoral fraud, not bribery or corruption. And in fact, in ZXC, a case of bribery and corruption, Lord Justice Simon held that the claimant did have a reasonable expectation of privacy. And so it is exactly that point that we are making here. In ZXC, the claimant was under investigation. So even more so, the appellants in this case have a reasonable expectation of privacy because they are not under investigation. And I wish to also point out that in ZXC, at paragraph 121, which is MS 1461, it is clear that there was a considerable amount of information available publicly in the ZXC case, just as in this case, there would have been a lot of information already in the public domain. But that did not stop Lord Justice Simon from indicating that there was still a reasonable expectation of privacy, because he points out at paragraph 121 that although the information already in the public domain was no longer confidential, the claimant was not trying to stop what was already in the public domain. his claim was closely focused on what had been published in the article. And similarly, I would say here, the appellants are not here concerned with what is already in the public domain. They are only concerned with the further evidence that would become available in answer to the questions of the Dutch authorities. Just as Lord Justice Simon says that he sees no reason to disagree with the judge's view that there was no sufficient public interest to justify disclosure of the letters of request contents, and that the confidentiality of the club's investigations should be maintained, we would submit that the court should not sanction the wrongful publicizing of information, because there is no principle that the evidence given during the course of the investigation should also be public. This would be a further breach of confidentiality for which there is no sufficient public interest to justify disclosure, as shown by the case of ZXC. The confidentiality of the investigation ought to be maintained. In relation to irrelevant considerations, this is the appellant's alternative argument. If your lordships find that the judge was entitled to exercise a discretion in relation to whether to give evidence, to take the evidence, in public, the appellant submit that it was exercised improperly and in a sufficiently flawed manner to justify the intervention of the appellate court.
If you're moving to that new point, Ms. Robinson, we'll take a short break now, just 3 or 4 minutes, please. Thank you. Ms. Robinson.
Great, Lawrence. So I'm sorry for that, Lord. As an alternative argument, if your lordships find that the judge was entitled to exercise a discretion in relation to whether or not to take the evidence in public, the appellant submits that it was exercised improperly and in a sufficiently flawed manner so as to warrant the intervention of the appellate court. Although the learned judge below recognized at paragraph 20 of his written reasons that the witnesses were being asked to answer some questions that will assist in criminal investigations in the Netherlands, that fact seems to have eluded him when he analyzed the situation before him. Instead of keeping the evidence-taking nature of his function in mind, he demonstrated a belief that a public hearing would end speculation and put to rest unfounded allegations at paragraph 38 of his judgment. Clearly failing to give consideration to the human characteristic to assume the worst and overlook the fundamental legal principle of being innocent until proven guilty, of which Lord Simon spoke, ZXC and Cooper. The learned judge below also seemed to be of the mistaken belief that there would be a determination of liability, criminal or otherwise, at the end of the question. Heavy reliance was placed on the public nature of the subject of the investigation by the learned judge below, in his decision to weigh the conflicting public interests involved, as was done in Hodgson against Imperial Tobacco. However, unlike in Hodgson, the learned judge did not in fact consider any competing interests. He mentioned only the need to protect the administration of justice, recognize and protect the freedom of the press, and the right of the public to be informed about matters he called of national importance. But these are all matters on the same side and in favor of a public hearing. There was no consideration whatsoever given to factors militating against a public hearing, including the tainting of the evidence for the overseas and any local proceedings. In fact, the only consideration that was given to the possibility of local proceedings was that it justified that the public had an interest in hearing the evidence. The judge concluded by saying that where the investigation is shown to be concerned with issues in the public sphere, that will tilt the scales in favor of a public hearing. The judge clearly had irrelevant considerations in mind, as there was no hearing contemplated, even by the DPP herself, only the taking of evidence. Such a comment in relation to any other evidence-taking exercise would not normally be countenanced. Although the learned judge below took into consideration the public status of the appellants and the assistance their public giving of evidence might lend to increasing cooperation with law enforcement to achieve the aims of justice, the nature of the allegations and the public's right to know these matters of national importance, he did not properly consider other features of the origins of the confidential letters of request, other than to indicate that a public hearing would not foster some Machiavellian aim of a political rival. For example, at no time did the learned judge indicate why the fact that the investigation was instigated by the leader of the opposition, Mr. Golding, at a time when all of the appellants were members of the government and the Netherlands was not designated under the Mutual Assistance Criminal Matters Act to receive or request mutual criminal assistance. The judge did not indicate why these factors were inconsequential to the exercise of his discretion. This is concerning, given that the Netherlands was so designated under the Act very shortly and only after the change of government, demonstrating that Mr. Golding's administration quite likely lent its assistance to the investigation that he had caused of a political rival. The first ground for refusing a request under the relevant UK guidelines is if the request relates to an investigation or prosecution which is politically motivated. It is hard to see why this instigated investigation of a political rival in an election season would not fall under the category of politically motivated, despite the short shrift that was given to that argument by the Constitutional Court.
Ms. Robinson, there's a question from Lord Leggett.
I'm trying to unmute myself. It was the Dutch authority that was undertaking this investigation and asking for assistance. There can be no suggestion, can there, that the Dutch authority in making that decision was politically motivated?
The evidence in the bundle, starting with the letter from the opposition leader, Bruce Golding, which is at MS 125, shows that it was not commenced, the investigation by the Dutch authorities was not in fact commenced by the Dutch authorities. It was on information from the opposition leader, Mr. Golding. So that letter of October 23, 2006 at MS 125 is what started the ball rolling. And then when one looks at the first supplementary letter of request, the original letter of request, which is at MS 130, there, the December 3, 2007 original request is in fact addressed to the Office of the Prime Minister of Jamaica, not to the central authority, showing that there was a deep relationship between the opposition leader and the Dutch authorities in relation to how this investigation began. Additionally, at the time of the original letter from Minister Golding, the leader of the opposition, Netherlands was not a designated state under MACMA and so could not have asked for the assistance. It was only after Mr. Golding became Prime Minister that the Netherlands was designated a foreign state under MACMA.
But this says that the criminal investigation was set up in January 2007.
Yes, it does. And that would have followed from the October 2006 letter from the opposition leader.
So I see. Thank you.
And so it is not that we would say, for instance, that the judge was politically motivated, or even that the DPP was politically motivated, but that the investigation itself was politically motivated. And that being aware of that, the judge should not have sanctioned the desired spectacle by taking the evidence in open court with media access. Additionally, it is clear that the allegations against Traffic Bureau, if proven true, would likely result in the 5 appellants facing allegations under Jamaican law. Where there is a bribe, someone has been bribed. Indeed, this was why the judge said that the public had a right to know their answers to the questions posed by the Dutch investigating authorities. Aware of that, it is curious that the judge, in exercising his alleged discretion, did not consider affording any privacy to them, such as would ordinarily be granted to a witness and indeed a suspect in a question and answer, and as was done in ZXC against Bloomberg. Indeed, it was precisely for this reason that it ought to have been incumbent upon the relevant authorities, and here I'm referring not just to the judge, but also to the central authority, to make doubly sure that all of the usual safeguards in an investigation were in place and not usurped for irrelevant and insufficient reasons. Any local investigation and subsequent court proceedings could also have been prejudiced by a public taking of the evidence, making it clear that the decision to make it public was an irrational one and based on irrelevant considerations, while failing to take into account these relevant factors. It ought, therefore, to have been overturned by the Court of Appeal. However, the Court of Appeal focused on the court hearing and not on the fact that this was really the investigative stage, an evidence-taking exercise at the investigative stage, not under the jurisdiction of the Supreme Court, only considered the risk of hostile questioning at the evidence-taking exercise, and found that because the appellants knew the precise questions that they would be expected to answer, they would be in a better position than others and remain fully protected by their right to legal representation. This was insufficient, however, because the very relevant fact that these appellants could have been facing allegations under Jamaican law ought to have been a consideration, where in fact neither the court below nor the Court of Appeal even addressed their minds to it. The usual steps in our jurisdiction taken to bring local proceedings against the appellants. I'm sorry, I think I skipped some. If the usual legal steps in our jurisdiction are taken to bring local proceedings against these appellants, there is absolutely no doubt that the Jamaican public will have a right to know about the matters subject of those proceedings. However, the prioritizing of the public's right to know over the relevant law and procedure involved in the taking of confidential investigative information for the benefit of an overseas country, cloaked in a desire to further the administration of justice in Jamaica, does not remove the obvious public spectacle it would have achieved, and that would have been antithetical to the administration of justice, both in terms of the overseas proceedings and any to be considered local. The Court of Appeal indicated that less weight might have been given to factors relating to the appellant's status, but that it was nevertheless of the view that this was not a determinative factor when the fundamental importance to the administration of justice of the open justice principle and the public interest involved in maintaining it in a society governed by the rule of law was considered. One wonders whether consideration was given to the negative impact on public confidence in the administration of justice in Jamaica that could have resulted from the public taking of evidence if the appellants were ever to face trial for the necessary corollary offences to those for which trafficker was being investigated, and had their claims for breach of the right to a fair hearing because of tainted evidence upheld. You see, my lords, the entire discussion in the courts below has really been focused on this idea of public administration of justice. And that is where it seems clear to me that errors were made, because there was a focus only on the public right to know. There was no consideration of the individual appellants and of the possibility for future criminal proceedings against them, and of just the general confidentiality that ought to attach to letters of request. As was indicated in the judgment granting leave to this court, this is an appeal of general public importance because the Mutual Assistance Criminal Matters Act is new legislation. There are no regulations under it. And certainly the procedure under Section 20 is not at all clear. This court commenting on the proper course that ought to be taken, the general consideration of confidentiality in relation to letters of request, and the safeguarding of investigative procedures for the overseas court and the local court are very important points that certainly the Court of Appeal was interested in hearing when it sent this appeal this far. And so we would certainly submit that the spectacle, the public spectacle that was created, and that certainly would have been created if there was a public taking of the evidence 50 years ago, would be avoided altogether. And public confidence in the administration of justice would in fact be further if the letters of request and the subsequent evidence taken are treated confidentially, as is expected under the treaty, as occurs in the UK, and as is currently provided in the local guidance published by the respondent himself. It is submitted that the appellant should be, as the Court of Appeal said, equally entitled to the same fair consideration that their fellow citizens now enjoy. Unless you have any further questions for me, my lords, for those reasons.
Yes, thank you, Ms. Robinson. I don't think there are any questions at the moment.
Well,
please. Right.
For those,
Thank you.
for those reasons and those in our written case, we respectfully ask your lordship to allow you.
Yes. Thank you, Ms. Robinson. Mr. Knox.
My lords, my lady, my submissions can be summarised as follows. First, a discretion does exist under MACMA to conduct questioning of witnesses in open court, not only A, where criminal proceedings have been instituted in the foreign state, but also B, where, as in this case, and I quote now the very words themselves in the Act, there is reasonable cause to believe that an offence in respect of which such proceedings could be instituted has been or is likely to be committed. And the reason I say that, or the reasons I say that, essentially come down to three. First, neither section 20 of the Act, which is the section which gives the judge a power to take evidence, neither section 20 of the Act nor any other provision requires there to be any difference in the procedures to be followed in the two situations. Therefore, just as the discretion to take evidence in open court, I submit obviously exists in the first situation, that is to say, when criminal proceedings are on foot abroad, so too it does in the second, that is to say, when there is reasonable cause to believe a relevant offence has been committed. That's the first reason. No distinction between the two situations in the Act itself. Second, and I submit really this is the crucial point, the Act, by authorising a judge of the Supreme Court or a resident magistrate to take the evidence, authorises him or her to do so as a judge of that court, and I emphasise of that court, and not merely as some sort of private individual, like some sort of glorified arbitrator. He or she is acting on the court's behalf, or sitting as a court officer. I say that first because this is both the natural construction of section 20, and I also say, were there any doubt on the point, were it otherwise, there would be no effective mechanism for enforcing the judge's or the magistrate's orders to answer questions by contempt of court proceedings. If the judge or magistrate is simply sitting there but not vested with the powers of court, what can he or she do if the witness says, not answering that one? And I say it would defeat the whole purpose of the Act, were it the case that the witness could not be compelled, or at least sanctioned, by proceedings for contempt of court for not answering the relevant question. That's the second reason. The third reason I make this submission is that the taking of evidence does not contravene section 19 of MACMA, as there is nothing in either the general or any specific law of Jamaica which requires such questioning to be done in private, nor is there any particular procedure which requires that. So that's what I say about the existence of discretion. Second, on the question of whether there was a wrongful exercise of discretion, I say there was none. Essentially for two reasons. First, when you look at the arguments, and it's very important always to look at the arguments raised before a judge, when you look at the arguments raised before Mr. Justice Campbell, he dealt with all the arguments perfectly properly, and there was no error of law or wrong discretion. Subject only, perhaps, to the criticism the Court of Appeal made, or the adjustment the Court of Appeal made to his reasoning, namely, he may have attached too much weight to the appellant's public status. Does the Court of Appeal held that makes no real difference? So I say no error of law or wrongful exercise of discretion, and perhaps more particularly, my lords, I submit that as both the judge and the Court of Appeal held, it is proper to start with the principle that proceedings in court must be in open court, or rather the open justice principle, albeit the nature of the proceedings can...
I'm afraid we've got a problem. Lord Hamblin has disconnected. Sorry about that, Mr. Knox. We'll wait for a minute. Mr. Cox, I'm sorry your submissions were interrupted by a technical problem. I think we're live again now. And I'd be grateful if you could pick up from the second submission within your first submission.
Yes. My lords, do you want me to repeat the second or move on to the third? I think
No, to repeat the second one, please.
To repeat the second. Yes. Within the first submission relating to whether a discretion exists.
Exactly.
Yes, the second point I say as to whether a discretion exists is that the Act, by authorising a judge of the Supreme Court or a resident magistrate to take evidence, authorises him or her to do so as a judge of the court. This is both the natural construction of Section 20, the relevant section, and secondly, were it otherwise, there would be no effective mechanism for enforcing the judges or the magistrates' orders to answer questions by contempt of court proceedings or the sanction of contempt of court proceedings. That would render, or rather defeat, the whole purpose of the Act. It would reduce the judge or magistrate to some sort of arbitrator without any particular powers to require witnesses to answer the questions, or indeed people to produce documents. The third reason I say that there is a discretion in the Act to take evidence in public in this type of case is that the taking of evidence does not contravene Section 19 of MACMA, as nothing in the general or specific law or indeed procedure of Jamaica requires such questioning to be done in private. So that's my first point. Basically, discretion exists to take in public, to take evidence in public. Our second point is that there is no basis for interfering with the Court of Appeal's discretion, or rather its decision to uphold the judge's exercise of his discretion. First, I say one has to approach the judge's exercise of discretion by reference to the arguments that were raised before him. And by reference to those arguments, there is no error in his discretion, save perhaps that he gave too much weight, as the Court of Appeal held, to the appellant's public status. But that, I say, makes no difference, as the Court of Appeal held. Secondly, I say on discretion, both the judge and the Court of Appeal were right to hold that the open justice principle applies to MACMA proceedings, including to those of the sort which we now have before us in this case. Albeit, of course, how the principle is to be applied will necessarily have to be tailored to the particular facts of any given case, and to the fact that, as the Court of Appeal held, this is more an investigatory hearing than a hearing with a view to determining guilt or innocence of itself. So those are my two submissions. I propose, my lords, my lady, first to make a few points on the facts, then to deal briefly with the judge's judgment at first instance. I then would like to look at the full court's judgment in the constitutional motion the appellants brought, because to a certain extent it explains in rather more detail why both the judge and the Court of Appeal were justified in holding as they did, and then I will deal with the specific arguments raised by my learned friend. My lords, my lady, just going to the facts for the moment, the Netherlands' initial letter was sent on the 3rd of December 2007, saying that they wanted 3 inspectors to come over for a hearing on the 7th, to come over to Jamaica on the 7th of January 2008, so they could make various investigations and ask questions of people. Now, my lords, given, my lady, given the point made by my learned friend arising out of the ZXC case, I perhaps should show you the initial letter from the Netherlands, because what it shows in particular is that this case, as well, this matter, and the appellant's role in the alleged bribery by Traffic Area was public knowledge already by that stage. So the notion there's some sort of confidentiality in this investigation at the moment it starts is quite untenable. Everyone knows about this, it's notorious. And it's an important part of the background, especially in determining the question of did the judge go wrong in exercising his discretion. And you can pick that up, my lords, that the letter itself, I think, is at page 130, or MS 130, or MS or electronic 132. My lords, I wasn't quite sure whether I should go by MS or electronic, because it's the first I've done it.
I think we have it at page 130 of the electronic bundle.
Ah, yes, I see, my lords. Yes, it is 130. It's also 132 if you type in the page number, rather confusingly. So in other words, if you want to skip from page to page, you don't put in 130 for this, you put in 132 at the top. But anyway, I shall say 130.
Right.
And that's how it comes out, at least on my...
You've got the document anyway, Mr. Knox.
You've got the document. Okay, I'm sorry for yes, okay. And this, here's the letter. And you'll see at the top of the page, 3rd of December, and it's come from National Public Prosecutor's Office and so on and so forth, addressed to the competent judicial authorities of Jamaica. And they draw attention to, Your Excellency, I'd like to draw to attention the following matter. Criminal investigations set up under our responsibilities, public prosecutors, and so forth, into Trafiguera. And they say the offence is punishable under the following Dutch criminal law sections. They then go on to set out a brief statement of case, page 130 to 131, and then 132, top of the page, announcements in the Jamaican media. And it then sets out, I don't propose to read it all out, but it sets out in the first, well, essentially on this page, going over to page 133, all within section E, the amount of publicity that's been attached to all this. Everyone knows about this. It's talking about newspaper reports and so forth. So this is not some sort of confidential matter. This is a well advertised matter, which has been advertised in the press for a considerable amount of time. One then, my lords, goes on to page 137, and you will see as attachment 1, about halfway down, after they set out the various people they'd like to speak to. As attachment 2, you'll find the questions we'd like to ask the witnesses. And then when you go to, I think I'm right in saying, so it's the first attachment. Page 137, you have as the first attachment. Schedule of investigations in addition to requests for legal assistance. You'll see about halfway down the page, Your Excellency, it is my honour to request you to have the investigation carried out according to the schedule set out below. The following circumstances necessitate the swift execution of the investigations requested. The Jamaican press announced this investigation in its publications. Since this pertains to the interview with the Prime Minister, former Prime Minister, and a number of other ministers, in their capacity as witnesses, it is expected that both this investigation and the witnesses will receive a lot of attention in the media. Therefore, we want to carry this out as soon as possible. Now, the reason I emphasize this is if that's the background against which the judge has to make his decision. We are not talking here about an entirely private matter, which no one knows about. We're talking about a very public matter, which everyone knows about, and indeed which the Dutch investigators want, if they can, to have heard as quickly or dealt with as quickly as possible. Now, my lords, if I may go now to page 14, which is the affidavit, which was not contradicted, made by the DPP in support of the application for an order. If I can pick it up at page 14. Para 13, perhaps. Para 13. The Dutch investigators travelled to Jamaica, and that's in January 2008, to seek interviews with the potential witnesses. They met with a few persons who were willing to assist them. With respect to the defendants, and that essentially is the appellants, I'm advised by the Senior Deputy Director and believe that several attempts were made to meet privately with them in the presence of counsel. I've also seen the notes of the failed attempts to meet. More than one agreement was arrived at. On each occasion, the attempts were thwarted, even though considerable expense was incurred travelling to Jamaica for the purposes on the faith of these agreements made by Mr. Knight, QC. And then she goes on to say what happened with the first agreement to interview on the 14th of January. These meetings were put off after Mr. Knight, who indicated he appeared for all save the sixth defendant, Mrs. Portia Lucretia Simpson-Miller, that's the fifth appellant here, advised that his clients would be no longer able to meet with the Dutch investigators. Based on that retraction of agreement to meet, it was freshly agreed to meet during the week of 4th of March. During that week, meetings took place, 4th of March, but from the meeting notes, it appears that each defendant, with the fifth defendant now represented by Mr. Knight QC, made the same assertion seriatim, that she wished to know who was the public official alleged to have bribed, and if that information was not forthcoming, she could not assist the investigation. It's clear from the notes of the proceedings that a prior agreement must have been arrived at to frustrate the process by offering no answers to the very detailed and specific questions to be put to the defendants and witnesses. And then she continues in the next paragraph, jumping ahead now in the story, to after the 9th request, supplemental request by the Netherlands, there now appears to be no other way to secure answers to the very specific questions raised by the investigators. And based on the material which they've shown you, the defendant should be asked to offer explanations for the benefit of the requesting state for the circumstances leading up to the 3 payments identified and traced into the relevant bank account and coming from Trafigura. The requesting state should also be allowed to ask other questions that arise from the course of their investigation, and so forth. So, my lords, that's the background to the matter. And I submit it's quite a useful background in this sense. My learned friend's case, or might appear at least to come to this, that there would be nothing that the court could do, even if the defendants rolled up at, let's say, a hearing in front of someone who was a judge, and they just said, I'm not going to answer that question anymore. And I submit this is exactly the problem to which MACMA was addressed, namely to force people to give evidence on the usual sanctions, that if they fail to do so, they'll be liable, guilty for contempt of court, subject, of course, to the rights which any witness has not to incriminate themselves, and whatever other rights they have as witnesses at common law. But I submit this history is a rather good example of why MACMA has to have some teeth. My lords, on going to page 5, if I may. That may be. Page 5, the fixed state claim form sets out the grounds on which the DPP brought this application. And it relies on the letters of request, grounds A, B, and C, and then Mr. Justice Anderson, my lords, forgive me, I have a bad reference for this, but on the 17th of October 2010, Mr. Justice Anderson ordered, on an ex parte basis, that a hearing take place pursuant to this fixed date claim form, and the eventual date fixed for that hearing was the 14th of November 2010. Now, 5 days before that date, the appellants issued a constitutional motion seeking to set aside Mr. Justice Anderson's order for there to be a hearing. And I'll come briefly to that later. Now, at the hearing itself, that is the hearing itself before Mr. Justice Campbell, which took place on the 14th of November, the appellants essentially took 2 points. First, that the hearing, and this was the full hearing, I should say, or intended to be the full hearing. First, it should be in chambers. Second, that the hearing should in any event be stayed pending determination of the constitutional motion. And my lords, for a summary, and my lords, my lady, for a summary of the arguments that were raised before the judge on this hearing, can I ask you please to turn to MS 694, page 694, paragraph 30, where in our respondent's case, we set out the nature of the arguments that were put before Mr. Justice Campbell for saying that the hearing should not be held in public and should be held in chambers instead. In chambers being used as synonymous with in private. So 694, paragraph 30, you'll see paragraph 30, subparagraph 1, Mr. Knight QC for first and second appellants basically said Jamaica's treaty obligation shouldn't be carried out at the convenience of another treaty state. He said there's no procedure for questioning to take place in open court or openly in a police station, and such procedure was prejudicial. Didn't really spell out what the prejudice was. He also said that the whole proceeding was politically motivated. And that was also said by Mr. Atkinson for the third appellant. And he pointed out that the law said that the law had been changed ex post facto to include the Netherlands into the relevant schedule in MACMA. And this would violate his client's constitutional rights. And it would violate constitutional rights to have questioning done in open court. And similar submissions were made by the others. So, my lords, that was the nature of the objection. And it wasn't, as far as I've been able to make out, specifically said, well, you know, trouble is we might ourselves one day be investigated for this, and we might be prosecuted. And this would prejudice any potential defence we want to make were we to be prosecuted. So it's not a particularly full set of submissions made in support of the application to have the hearing held in private. Mr. Justice Campbell gave an extemporary ruling.
Lord Legate.
It's just a clerical one. Do we have the documents that you cite in your case?
Yes, I hope so. In other words, the references.
Yes. So
Yes.
are those the page numbers in our bundle there? If we
Yes.
take 258, we'd find that, would we?
You'd find that, yes.
Okay.
And so forth. My lords, I could take you through it, but I think it might be a bit laborious.
I just wanted to know whether we've got the materials if we wanted to look at them.
Yes, my lords, you do.
Thank you.
And those are the right, and I think you just click and you go straight there.
Okay.
My lords, going to Mr. Justice Campbell's ruling, that's at page 376. And he, first of all, deals with the application for a stay, very briefly. He says, I'm not going to stay today's hearing pending your constitutional motion. Not totally surprisingly, given the constitutional motion had only been issued 5 days beforehand, and one can't help wondering what in real life what was going on. But anyway, he says, I'm not going to stay these proceedings. And then he goes on in the second paragraph to say, in respect of the application for the matter to be dealt with in chambers, meaning the hearing be done privately, and persons other than me, that would mean the press, be excluded, and other persons not directly interested in the matter, I believe that's the brunt of it. That's also refused. The court sustains a common theme of openness in proceedings. At the same time, each has said that chambers plays a significant role. It is unlike this, be it this decision, practice will be heightened that the judicial process in its different manifestation is essentially a public function. My lords, it seems to have got a little bit garbled at the end, but one can, I think, see what he's basically saying. This is the administration of justice is a public function. My lords, one of the things that had happened in the course of the hearing is that the judge had drawn to the parties' attention the Court of Appeal's decision in Hodgson and Imperial Tobacco, which was a decision where the Court of Appeal held that even though in Queen's Bench action the hearing was in chambers, that didn't mean it should be treated as having been held in private. And the Court of Appeal disapproved of the notion that a hearing in chambers should necessarily be a hearing in private. And the judge had drawn that to the parties' attention and asked them for submissions on it. And so that's the context in which he is saying there should be a common theme of openness in civil proceedings in any event. And that's why he talks about, at the same time, each has said that Chambers plays a significant role. It's against the background of the case of Hodgson. My lords, after the judge's judgment, but before he gives a written judgment, long before he gives a written judgment, proceedings in the Constitutional Court to set aside continue, and they, which essentially seek to do two things. First, they seek to set aside Mr. Justice Anderson's ruling that there should be a hearing at all of the DPP's claim for the taking of evidence. And secondly, they also sought to attack the judge's ruling that the matter be heard in open court. And they said, and they based those challenges on constitutional grounds. And my lords, if I can just ask you please to go to page 697. This summarizes the page. This is an extract from our written case, and it summarizes the nature of the of the court's argument. And my lords, it's important to bear this in mind when looking at the discretionary factors. My lords, it held, the first thing it held was that the abuse of process argument based on the government's motive, or alleged motive, in passing the 2007 order, which made the Netherlands essentially a party to the MACMA process, was, quote, devoid of merit. And there's likewise no evidence to satisfy the court that the DPP's action was influenced by political considerations. My lords, I submit that's an important point. My lords, perhaps in particular, can I ask you to go to page 1339. MS 1339. Para 78. The claimants have alleged political motive not only behind the passing of the relevant order, but also behind the DPP's claim that led to the Anderson order, Mr. Justice Anderson. They made heavy weather of the fact that it was Mr. Golding who instigated the Dutch investigation of the matter. The case being advanced on this basis is that the DPP's claim is politically motivated, and that's what made the Anderson order an abuse of the process. As Mr. Martin put it, Mr. Golding was the initiator. And then she goes on to deal with the prosecution's reply at para 79. But eventually, she makes this point, para 81. There is no evidence or assertion that the second respondent's granting of the request was unlawful because the request relates to an offence or proceedings of political character in the Netherlands. And then 82. Had the claimants made such evidence supported by credible evidence to show contravention of section 16(1) of MACMA, which relates to political offences, then they would have stood a better chance to mount a case worthy of serious consideration on this issue of politics behind the request. In Crown against Secretary of State and so forth, the point was raised whether the Secretary of State should give consideration to whether an offence was a political offence for the purpose of deciding whether to grant or refuse a request. Their lordships decided, as the head notes disclose, that the fact of an offence was committed in a political context does not make it a political offence per se. And my lords, that one drops down to 85 after further discussion of the point. All this has led me to conclude, therefore, that whatever Mr. Golding's motive or purpose might have been for alerting the Dutch about traffic errors payment is essentially totally irrelevant to the action of Anderson J in granting the order. And then 86. Furthermore, once the foreign state's order is accepted as being valid and constitutional, which is presumed to be, then any action that was taken by the learned judge pursuant to it falls within the purview of substantive law to review by the appellate court, not by this court. My lords, the reason I emphasise all this is that one can well understand the general point made by the appellants is that all this is politics. The answer to that is yes, but that point has been dealt with in the constitutional motion. And the court said, well, that may be right, but you haven't really come up with much on that, and there's no infringement of your rights. And in particular, the relevant order, the 2007 order, is a good order. It's not been set aside, and the DPP, in my respectful submission, was bound to act in accordance with it. And therefore, it was inevitable, in my submission, that the hearing had to be in court on any footing. So the only question then is, was it to be an open court or in private?
That might be the point, Mr. Knox, at which to adjourn. We'll resume at 2 o'clock.
I'm obliged, my lord.
Thank you very much.